Well, welcome everybody, and those who are still coming in. There's still some more coming in. This is great. Um, we're really honored to have Ambassador Anton Korenevych with us today. Um, it is November the 3rd, 2025, and this is our course on international crisis management. Now, I see Justice Elena Fanova is on the call. Maybe she would like to unmute herself and explain how she managed to get such a fascinating session organized. Would you care to do that, Judge Fonova? You, yes.
Uh, I'm sorry, I have some problems with internet, and maybe I hear you not good.
Oh, I was just inviting you to say hello and to launch the session if you would like to. Um,
Hello, everybody. I hope that this lecture will be very interesting today because Anton Korenevych is a high professional in Ukraine, and I'm proud that I know him. So he's a great professional, and he do a lot of useful and powerful things to Ukraine in field of international in international field, and I think that his lecture today will be very interesting for all students, for all people who invite on this lecture, because it's a very great experience, and I think for Ukraine, it's maybe not a pleasure experience, but today we have some results of about this, and better, I think, can explain this, Anton. Sorry for my English.
okay. No, your English is perfect. Elena Fonova, you are a great friend and solid support of this course. While uh, while we're on the topic, for those who speak Ukrainian, November 19th, uh, I think I hope that Elena Fanova will be available to help get that discussion going in Ukrainian language. The new ambassador from Moldova to the United States, I attended a lecture that he gave last week. He is outstanding. He sees things in historic perspective. He understands. He's able to explain the very tricky role and the pivotal role that Moldova has in the region. Tiny country, 2.5 million. Um, but look at where it is on the map. And of course, we have Transnistria. He will speak in Ukrainian Wednesday, November 19th. So anybody who's interested in that, I invite you. Now, let me just take maybe 2 minutes. When Professor Marcy Shore spoke to us a week ago today, she mentioned the notion of turning point. And this is a big concept in crisis management and in strategy. The Baron von Clausewitz, in his work on, it's called On War, and it's sort of a classic that people look to for guidance in dealing with a military conflict. He talks about in German the Wendepunkt, the Wendepunkt. Now, this is a curious thing. Nobody's ever explained this. I just wanted to take 1 minute. There may be exceptions. In my observation and my experience, every dictatorship, no exceptions, every dictatorship has this kind of a demonic uh, amount of power. Nobody knows where it comes from. It's something quite crazy. And I'm thinking of one of the dictators in Haiti when I lived there. He accumulated power like this, and then came the Wendepunkt. It always comes. I'm saying this because to me, this encourages me about the Ukraine situation with respect to Vladimir Putin. Dictators I think without exception, there comes a point, we never know when and we never know how. There comes a point when they lose everything. Um, and I wanted to read a brief passage from, the American diplomat that you're familiar with is Benjamin Franklin. I think our best diplomat was John Quincy Adams, the son of John Adams. He was an amazing diplomat. He was U.S. ambassador shortly after the creation of the United States in 4 or 5 important countries, including Russia during the Napoleonic invasion. And in those days, you didn't have telegraph, you didn't have WhatsApp. Uh, Diplomats used to write very long and thoughtful letters. The letter would go by ship and it would arrive 6 weeks later. Here's at the moment when Napoleon was defeated in Russia, that was the Vendepunkt, right? And he was stupid. He overextended. He did. This was absolutely crazy to take 400,000 volunteer soldiers, invade Russia in the wintertime. I mean, we talk about Napoleon's genius. Um, and in his letter, John Quincy Adams uses the genius. He uses the 19th century version of air quotes by capitalizing the word. Let me just read this. Um, those of France have been in the vitals of her military power. The spell of Emperor Napoleon's name is not yet totally dissolved. This is after the defeat of 1812. His friends yet cherish a vague and general hope. His enemies feel an involuntary fear that his transcendent genius, so they term it, will yet burst forth, chain down fortune at his feet, and range the world again, conquering and to conquer. I see no substantial ground for such a hope or such a fear. The highest probabilities are that his fall will be as great as his elevation was extraordinary. And with regard to his genius, air quotes, if it ever surpassed that of other generals and statesmen, it has most assuredly deserted him in the undertaking and in the execution of the war. That he may still maintain his authority in France, it would be presumptuous to deny. That he may again collect armies and win battles is altogether possible. But in the tenor of human history, when fortune, capital F, he personalized, when fortune has once turned her back upon those whom she has been most lavish of her favors, she never takes them in her arms again. I think this is a very beautiful passage, and I certainly hope that this is what happens to the head of state of the Russian Federation. Um, Ambassador Korenevych, we're so glad to have you here today. War crimes. Um, your professional experience has spanned many areas. You've been a representative of the autonomous region of Crimea to the presidency of your country. Um, you indicated last week that you'd like to talk about your work in prosecuting war crimes. Would you like to begin at that point?
Yeah, thank you so much, dear Professor Whitman. Good afternoon, or good evening, or good morning for those of you who are there in the Washington, D.C. I'm really very happy and honored and grateful to be present today on this lecture of Professor Whitman. And my, of course, sincere gratitude goes to my good friend and colleague, Ms. Olena Fonova, Justice Olena Fonova, for gathering us here today and for me to be able to talk with you on accountability efforts of Ukraine, which we are currently working on in order to ensure full and comprehensive accountability of the Russian Federation, and also the restoration of peace and justice, long-lasting and comprehensive peace for Ukraine. So I will then probably talk for a little bit about what our efforts are, what do we do now, what our current actions are, and then of course I will be happy to try to answer to your questions and queries if they appear. So as many of you may know, the Russia's aggression against Ukraine started in 2014. So it was late February 2014 when a Russian Federation started its operation of occupation of the Crimean Peninsula, namely of the Autonomous Republic of Crimea and the city of Sevastopol. And also it was early April 2014 when the Russian Federation started military actions, hostilities, first in Donetsk region, in the city of Slovyansk, and then in Luhansk region, which led also to the occupation of part of Donetsk region and pretty much of the whole of the territory of Lugansk region as of now. So we here in Kyiv, of course, do believe, and this is our message to the whole world, that the war of aggression of the Russian Federation against Ukraine started not in February 2022, but in February 2014, with the occupation of Crimea and the outbreak of Russia's hostilities and occupation actions in Donetsk and Luhansk regions. Therefore, starting from this very moment, from the end of February 2014, Ukraine started to seek international accountability mechanisms to bring Russia and Russian citizens, nationals to accountability for the violations which the Russian Federation committed, violations of international law, which the Russian Federation committed during its hostilities and occupation actions in relation to Ukraine. So as of now, as of November 2025, Ukraine uses each and every possible international mechanism and instrument to bring Russia and its nationals to accountability. Namely, we had 2 cases against the Russian Federation in the International Court of Justice. The first case is already over, finished, the case on the violations by the Russian Federation of the International Convention on Elimination of All Forms of Racial Discrimination and the International Convention on Suppression of Financing of Terrorism, CERT and ICSFT. This case was pending before the court since 2017 till 2024. And in the beginning of February 2024, the ICJ rendered a decision, a judgment, in which it decided that the Russian Federation violated both the International Convention on the Suppression of Financing of Terrorism and the International Convention on the Elimination of All Forms of Racial Discrimination in relations against Ukraine. So it violated the Terrorism Financing Convention in not investigating the terrorist activities in the territory of Ukraine, in particular in Donetsk and Luhansk regions, and it violated the Convention on Elimination of All Forms of Racial Discrimination because it had destroyed the education in Ukrainian language in Crimea, which led to total erasure of Ukrainian language from Crimea's educational system. The second case of Ukraine against Russian Federation in the International Court of Justice deals with allegation of genocide. This case was brought to the ICJ on the 26th of February 2022, so just 2 days after the full-scale invasion of the Russian Federation started. And its main plot is that the Russian Federation violated the international legal rules and norms, manipulated and speculated of the term genocide, of the concept of the notion of genocide, when it started its full-scale invasion in Ukraine. Just to remind to our audience, in late February 2022, Russia used a lot of public arguments, opinions that Ukraine committed some kind of a so-called genocide in the territory of Donbas, so in the territory of Donetsk and Luhansk Oblast regions, and that Russia's actions to start the full-scale invasion was in order to counter the genocide, because all other actions didn't bring any kind of results. So in this case, we argued that the Russian Federation manipulated, speculated, and misused the concept, the notion, and the very nature of the term and the concept of genocide in order to find justification for its full-scale invasion. So government of Ukraine as of now use ICJ as an international mechanism in order to bring Russia to accountability. We have also 2 cases against Russian Federation in the arbitral tribunals established under Annex 7 of the United Nations Convention on the Law of the Sea. So many of you, of course, know that the main international jurisprudence body on the law of the sea is, of course, International Tribunal of the Law of the Sea, ITLOS. But UNCLOS, United Nations Convention on the Law of the Sea, also gives the states the opportunity, the possibility to adjudicate cases in the special arbitration tribunals established under Annex 7 of UNCLOS. And that is how we have now 2 cases against the Russian Federation in such arbitration tribunals under Annex 7 of UNCLOS. The first case deals with the rights of a coastal state in Black Sea and Azov Sea, where we argue that the Russian Federation violated UNCLOS, United Nations Convention on the Law of the Sea, by its illegal activity in the Kerch Strait, by its illegal ecologically negative activity in the Black Sea region, Azov Sea region, by its negligence to secure cultural heritage, underwater cultural heritage, and many others. This case is now underway. And the second case, again, in the second arbitration tribunal established under Annex 7 to UNCLOS, is about Ukraine's warships, how we call it, warships case. It is about the one action during one day when Ukrainian 3 Navy warships tried to make a passage down the Kerch Strait on the 25th of November 2018, and they were shelled and then they were captured by the Russian Federation. So 3 Ukraine's warships and teams from Ukraine's Navy officers from these 3 Ukraine's warships. So this case is called warships case. And in this case, we argue that the Russian Federation violated UNCLOS, United Nations Convention on the Law of the Sea, by actually illegally seizing Ukraine's warships, which have immunity under UNCLOS, under United Nations Convention on the Law of the Sea. So these 2 cases are underway in both these Annex 7 UNCLOS arbitral tribunals. As many of you may also recall, Ukraine has also recognized jurisdiction of the International Criminal Court in 2014 and in 2015 twice, not being still a state party to the Rome Statute, but recognizing ICC's, International Criminal Court jurisdiction on the basis of provision 3 of Article 12 of the Rome Statute, which gives the state which is not a state party to the Rome Statute the possibility to recognize ad hoc jurisdiction of the International Criminal Court in order to explore and investigate several particular situations. And in 2014 and 2015, Ukraine made 2 such declarations on the recognition of the jurisdiction of the International Criminal Court under provision 3 of Article 12 of the Rome Statute. First declaration dealt with the crimes committed during Maidan protests by the law enforcement system and law enforcement officers. And the second case deals with alleged war crimes and crimes against humanity committed by the so-called Lugansk and Donetsk People's Republics, so by these terrorist organizations led and controlled by Russia. So on the basis of these 2 declarations, the ICC started the provisional examination of the situation in Ukraine. And then after the full-scale invasion of the Russian Federation to Ukraine started, the ICC started the full investigation of the situation in Ukraine. As of now, ICC continues its investigation of the situation in Ukraine. As of now, Ukraine has ratified the Rome Statute. We have done this in August 2024, so just I would say a year ago. Верховна Rada of Ukraine, Ukraine's parliament ratified the Rome Statute on 21st of August 2024. And since 1st of January 2025, Ukraine became the fully fledged member of the International Criminal Court. Ukraine became the 125th member state of the International Criminal Court. And for many of us, international lawyers here in Ukraine, the end of this journey to become the fully fledged member of the ICC is really a groundbreaking, I would say, activity and a groundbreaking result. So as of now, ICC continues investigation of the situation in Ukraine. As of now, we have 6 arrest warrants for the Russian nationals for alleged commission of war crimes and crimes against humanity. Namely, these arrest warrants are issued for Vladimir Putin, Maria Lvova-Belova, Sergei Kabalash, Vasily Sokolov, Sergei Shoigu, and Sergei Gerasimov for war crimes of illegally transferring, deporting Ukraine's children, and for war crimes and crimes against humanity of illegally targeting Ukraine's critical infrastructure, so illegally targeting civilian objects which have the protection under the international humanitarian law. Of course, you also may be aware that as of now, the ICC is under imminent threat of the sanctions by some of the states. In particular, the personal sanctions in relation to ICC prosecution and judicial officials are already in place. And also the ICC currently is under the threat of institutional sanctions. So sanctions which will be targeted not on particular individuals, but on the ICC, the institution itself. So we hope, and we are now, of course, in close relations with the ICC, that this whole situation will not bring any negative results in relation to the ICC's investigation of the situation in Ukraine, and that ICC will continue to be an active party when we talk about ensuring accountability for the crimes against international law committed in the territory of Ukraine. As you may also be well aware, Ukraine also seeks accountability of the Russian Federation in the European Court of Human Rights in Strasbourg. We all know that the Russian Federation was a state party to the European Convention of Human Rights and a member of the Council of Europe by 16th of March 2022. That means that European Court of Human Rights has jurisdiction to look at the cases against the Russian Federation where the facts of the cases took place before or on 16th of September 2022. So everything which happened before 16th of September 2022, European Court of Human Rights has the ability to look at and has the jurisdiction to work on cases against the Russian Federation. So that is why ECHR, European Court of Human Rights in Strasbourg, is also an important venue because there are several pending cases, Ukraine versus Russian Federation, which deal with the cases, with the facts which happened before 16th of September 2022. And while Ukraine uses all this available and possible international legal mechanisms, instruments, and tools to bring Russian Federation and Russia's citizens to account, Ukraine also started to work on filling the 2 existing legal gaps, legal loopholes, which we here in Kyiv, we believe that they need to be filled. These gaps, these loopholes should not exist if we want to be able to tell that we work in order to satisfy full and comprehensive accountability of the Russian Federation and its nationals. The first loophole, the first gap, is the absence of the compensation mechanism for the Russia's violations of international law. So as of now, we do not have any international compensation mechanism to which Ukraine's nationals would be able to apply in order to get compensations. So that is why we believe that this is a problem. And we believe also that United Nations Security Council, which would normally deal in such a situation, cannot work now because of the Russian Federation seat of a permanent member of the Security Council. So that is why, starting from 2022, Ukraine started to work to fill this accountability gap and to establish an international compensation mechanism, which would comprise of three elements. The first element is a register of damage, which we now know already exists in The Hague, in the Netherlands, and we all can send our applications there in order to be able to get some compensation in future. So the register of damage as a first element of the international compensation mechanism already exists. It is some kind of a database which secures and saves all the information, all the applications coming from Ukraine's nationals, nationals of other states, Ukraine's legal entities, business, which really got damages during Russia's war of aggression. The second element of the international compensation mechanism is being now established. It is called International Compensation Commission. It shall be an adjudicatory administrative body, so not a judicial body, but administrative one, which would comprise commissioners, and commissioners will decide on the basis from applications which are available in the register of damage. The commission will decide who shall get what. So who shall get which compensation on the basis of the analysis of the applications for compensation which were submitted to the register of damage. And hopefully the Open Convention of the Council of Europe on the establishment of the Claims Commission, Compensation Commission, shall be signed in December this year in The Hague. Fingers crossed, we work hard in order to get this done. And the third element of the international compensation mechanism shall be the International Compensation Fund. Because when the register of damage got all the applications, or got the applications which came to it in relation to the compensations, it rendered them to the International Claims Commission. Commission made its decisions, and the compensation fund shall decide who shall get which compensations from which sources, on the basis of the decisions of the Claims Commission. So this work is still to be done. So the compensation fund is still to be established, but we really hope that this fund can be established, and hopefully it will be filled with assets, principally Russia's assets, and this will enable the compensations to flow to those who will make their applications to the register of damage. And last but not least, but I saved this for the last minutes of my speech, last but not least element is again about filling the loophole, the gap, accountability loophole, accountability gap, which currently exists in international law in relation to Russia's violations of international law against Ukraine. And this gap and loophole is the absence of accountability mechanism for the crime of aggression against Ukraine. You know that now in November, we all will celebrate 80 years of International Military Tribunal in Nuremberg. And we all recall why Nuremberg Tribunal is so important for the heritage of international law, for mankind, for international justice. A Nuremberg tribunal dealt with three categories of international crimes committed by former Nazi leadership: war crimes, crimes against humanity, and crimes against peace, the crime of aggression. And our friend and colleague, Philip Sands, brilliant English author and professor, he counted that around 80% of all the information of the judgment of the International Military Tribunal in Nuremberg is about crimes against peace, crime of aggression, how we call it now. So we believe that we cannot leave the crime of aggression in the Russia's war against Ukraine without legal response, as current Russia's aggression against Ukraine is the biggest war of aggression after 1945. And unfortunately, no existing international judicial mechanism can ensure accountability for the crime of aggression. International Criminal Court cannot do this. We can talk about this later. So that is why, since the end of February 2022, we started to work on the project of the establishment of the Special Tribunal for the Crime of Aggression against Ukraine. We gathered political support from parliamentary assemblies of international organizations, from national parliaments, from expert society, from NGOs. We brought this issue really high on the agenda. We established the core group of states, of 40 states, which gathered 14 times for 14 meetings to draft statutory documents for the Special Tribunal. And these documents were, let's say, finalized in the end of March 2025. Mm-hmm. And on the 25th of June 2025, in Strasbourg, in the headquarters of the Council of Europe, President of Ukraine, Volodymyr Zelensky, and the Secretary General of the Council of Europe, Alain Berset, signed bilateral agreement between Ukraine and the Council of Europe on the establishment of the Special Tribunal. Less than in a month, on the 15th of July 2025, Ukraine's parliament, Verkhovna Rada of Ukraine, ratified this agreement with 323 votes in favor, no votes against, no votes abstained. It's more than constitutional majority. And as of now, we are working in order to adopt as soon as possible enlarged partial agreement on the management committee of the Special Tribunal. Management committee will serve something like the Assembly of States Parties, and hopefully we will be able to launch the activity of the Special Tribunal as soon as possible. So something which many of our partners believed in early 2022 is impossible, Special Tribunal, now became a reality, which is now legally already on paper. So now our main task is to make it operational. I think I will stop here, and of course, I'll be happy to try to answer any your query or comment or quote. Thank you, Professor.
Ambassador, your ability to recall dates and numbers is baffling. I don't know how a human being can contain so much information. And I later, but not quite yet, I want to ask you to provide advice to people on the Zoom call. I think approximately one half of our Ukrainian group are studying law, and I think they're studying human rights law, international law. You might have advice for them on how to develop the ability that you clearly have to keep this vast amount of information so clearly in mind. I have several questions. Elena Fonova posts this in the chat, and you might want to respond to her. It's a little bit long. Unfortunately, the Registry of Damages for Ukraine does not provide the possibility to submit claims or receive compensation in the future for individuals who suffered losses or damage before February 24th, 2022. This concerns the residents of Lugansk and Donetsk regions who were deprived of their property or suffered other types of harm in 2014, as you've noted, Ambassador, when the conflict really started, following the creation of the so-called Luhansk People's Republic and Donetsk People's Republic. Is Elena's question or point, is that something you'd like to comment on, Ambassador?
Yeah, thank you so much, Professor. And I'm also really grateful to Elena for making this question, because I mean it's an obvious one. So I would recall that for Ukraine, it is always imperative to talk about the fact that the Russia's Federation aggression against Ukraine started in 2014. But when our colleagues, mainly from the Ministry of Justice, started to work on this project of the Register of Damage, it came out that for many states, it's easier to start to count from 2022. And this is not because, they have some alternative views or they live in an alternative reality or whatever. For many of them, it's because we didn't have United Nations General Assembly resolution on aggression in Ukraine, so on calling officially the situation in Ukraine aggression before 2022. And we had the same issue with the special tribunal. So when the special tribunal shall start its ratione temporis jurisdiction, in 2014 or in 2022. So in the case of the Register of Damage, you are absolutely right, dear Elena. They have now the starting point on the 24th of February 2022. But I also know that my colleagues who work hardly and permanently on the Claims Commission project now, they now try to work with international partners to prolong this mandate, temporary mandate, to actions started in 2014. So Ukraine's efforts, Ukraine's team will continue to do what it can in order to bring this temporary deadline back to 2014. Let's see what the results will be. And in relation to the special tribunal, we had the same issue, but we decided it, I hope and I believe, in the proper way. So we left it for the judges of the special tribunal to decide when the temporal jurisdiction should start for each particular case. So the special tribunal shall have jurisdiction over the crime of aggression against Ukraine, full stop. And the special tribunal's judges will decide whether, for some of the cases, they will take as a starting point 24th of February 2022, or whether in some other cases, they will take as a starting point at the end of February 2014. We believe that in such architecture of plenty of use, when again, a lot of states, even the strong supporters of Ukraine, say that, but look, we have aggression resolution in 2022. We didn't have it in 2014. I believe that such a decision is the most wise one and the most, I would say, logical one. Thank you.
I think Elena is disappointed but satisfied, I think, with that response. I guess prosecutors, they say, always prosecute for the easiest crime to prosecute and go no further because they hope to get a prosecution that will pass in a court. Daria Hladka has a question related to one that I have. She says, what are the main legal challenges to using frozen Russian assets for compensation purposes? I would add to that I believe Ursula von der Leyen has come up with, I think, a brilliant idea, which is the 350 billion euros go to Ukraine as a loan, not as a gift, to be compensated when the Russian Federation pays reparations. That would be never. That seems like a rather brilliant move, does it not, Ambassador? Or is that so unrealistic that it might not happen? Daria's question is more important than mine. What are the legal challenges? I think that the use of the frozen assets, the resistance to that is more political than legal, in my understanding, but correct me if I'm wrong.
Thank you so much, Professor, and thank you, Ms. Latka. So when we talk about legal basis for the compensation of Russian assets, we use the concept of counterclaims, in Ukrainian kontrzakhody, countermeasures. So these countermeasures is an act which you do in order to counter internationally wrongful acts committed by other states. So, for instance, for the special tribunal for international criminal accountability, this is impossible. So countermeasures do not work in criminal law system. But for such issues as assets, it can work in principle, in general. So the idea is that since the Russian Federation violated international law in relations with Ukraine, and violated international law in relations with Ukraine many, many times, and committed severe, grave violations of international law. That's why both Ukraine and other international partners of Ukraine can provide countermeasures to Russia's violations. And one of that countermeasures can be confiscation of Russian frozen assets. So in terms of international law, it's no problem to freeze the assets, even the sovereign one, both private and sovereign one. It's okay. From the point of view of international law, it's some kind tricky to compensate sovereign assets because they are safeguarded by sovereign immunities. And now we have a question that many of European states, for instance, they consider that on the basis of the concept of countermeasures, Russian sovereign assets can be confiscated to the benefit of Ukraine. But also some of European states, even some of biggest Ukraine supporters, consider that Russian sovereign assets cannot be compensated because they are safeguarded by sovereign immunities. Most of this money is now concentrated in Euroclear, in Brussels, in Belgium, and Belgium is very cautious about doing something with those funds, in particular because of the alleged counteractions by the Russian Federation, in particular in litigation, in court procedures. So this work continues. Let's see how it goes. This is quite not an easy thing. But yes, Professor, as you mentioned, one of the latest events and latest news in this story is the idea to have this reparation loan, which again is a temporary measure before Russian Federation ceases its aggression. But we believe that this reparation loan, so paying a loan to Ukraine through the profits of the Russia's sovereign assets, in particular, which is now situated in Europe, is something, I mean, Ukraine needs any kind of assistance when we talk about monetary assets. And if reparation loan is something that can be practically possible for our international partners, it would be a good interim provisional measure for us. Thank you.
Totally personal, irrational reaction. Why can't Belgium just do the right thing? I mean, that's anyway. We'll get to Gleb Dolyanovsky in a moment. I'd like to ask you, Ambassador, you mentioned special tribunal. In the 90s, during and after the Balkans Wars, and in the terrible situations in Liberia and Sierra Leone, was created this concept of ad hoc tribunals. Does the history of those tribunals serve as examples for you in your current work?
Both yes and no, Professor. So yes, when we talk about the need to ensure accountability, and we look at these situations, which happened quite recently, I mean, in historic perspective, and we see that there were international efforts to ensure accountability for these situations. So with this said, I think these examples are quite close to us because we say, look, there was accountability efforts that time, we need accountability effort now. But also we understand that the situation there was different one. So now we are speaking about the open aggression of the permanent member of the UN Security Council. So we cannot rely on any actions on behalf of the United Nations, in particular on behalf of the United Nations Security Council, because Russian Federation will block these actions. So that's why we tried and we used some time, these core group meetings, in order to elaborate, in order to find the right option, the right model to establish a special tribunal. And we believe that this model of bilateral agreement between Ukraine and the Council of Europe gives us a good legal basis for the special tribunal's activity. So yes, we had, of course, taken into account each and every historic example of establishing international criminal tribunals, but we also understood that here in our situation, we need to have an original, authentic recipe, which will not be looking the same as any other tribunal existing in the past. Thank you.
Okay, and I may say if Ukraine succeeds in establishing this mechanism, you do a great service to the world. The Russian or the Soviet Union signed something called the UN Charter and Articles 6 and 7 on the peaceful resolution of conflicts. They signed this. Now, they might argue that the Soviet Union no longer exists, thank God, but I think it may have been tactically foolish to admit the Russian Federation into the Security Council because it was not the Russian Federation that was originally included. I don't know if you have any light to shed on why in the world would we have done that? Would we have thought that the Russian Federation might behave better than the Soviet Union did if they were brought into the Security Council? Do you have any thoughts on that? And then I promise we'll go to Gleb Dolyanovsky.
Thank you so much, Professor. Well, you know, there are a lot of comments and actions in order to counter legitimization of the Russia's Federation presence in the United Nations in general and in Security Council in particular. So I do not work on this. It's mostly political work inside international organizations. I work mainly as a lawyer, of course, but I believe that there are really very serious questions as to why the Russian Federation was admitted to the UN membership without any kind of procedural document on that, without any kind of United Nations decision on that. It's really very strange. So I think there is a lot of things to do on that track.
Yes, I wish we could relive that moment and reconsider. Presumably, the Russian Federation, in joining the United Nations, committed itself to Articles 6 and 7, presumably. And they're clearly violating this. And if a mechanism is set up by Ukraine, we thank you. We thank you for doing so. Gleb, you've been very patient. Your comment, Gleb?
Thank you, Mr. Wittman. And thank you, first of all, Ambassador. It's absolute honor for me as a Ukrainian to have such a brilliant diplomat and lawyer in our diplomatic corps. And thank you so much for your lecture. I would like to just ask the question which Mr. Wittman already apprised in a bit broader context about the historical experience of the Serbian and Croatian general wars in ex-Yugoslavia, particularly about the future of those who defend Ukraine nowadays. And I am very concerned about the future of them after the war, because we have historical experience of General Ante Gotovina, who was a Croatian general who was accused by International Justice Court and later during the International Criminal Tribunal for the former Yugoslavia. He was sentenced for 24 years in prison for his actions during the Operation Storm in 1995, when he provided the operation together with his units in the territory of illegally occupied by Serbia, Srpska Krajina, which reminds us nowadays about illegally occupied territories of Ukraine. And this historical experience, it's literally reminding as if Ukraine would provide some operations on the temporary occupied territories, and later on our soldiers, our generals would be accused by International Justice Court for this. So my question is, for us as Ukraine, as a country which ratified Roman Statute, unlikely from Russia, who, yes, they signed it but at the end of the day, they didn't ratify it after Crimea annexation at all. And is there a chance that we, as a civilized state which ratified Roman Statute, will be present in the court as accused people and will have our soldiers will have to defend their dignity and respond for their actions on war, unlikely from the Russian side, which will hardly be able to be demanded for their war crimes and other actions and their particular presence in Hague? Thank you.
Mm-hmm. And I think one aspect of Gleb's comment is, Ambassador, you mentioned the institutional compensation and the cases, frankly, on a higher level, whereas we know that there are over 100,000 cases of individual abuses committed by Russian soldiers. That would be, would you say that's a totally separate issue? Gleb, I think that your question includes that concept. If I'm wrong, forgive me.
Absolutely, absolutely. I
Yeah.
believe that the crimes, they are registered for all the sites, and that is why my main question is there a chance that if Ukraine, the country which ratified Roman Statute, will be responding for its own actions during this war, while the Russian side will not? And what we can do in order not to repeat the experience of the brave Croatian generals who were sentenced, but later on freed at the end of the day?
Thank you. That's a bundle of questions, Ambassador. Take whatever you'd like.
Yeah, thank you so much, Professor. Thank you, Mr. Doninovsky, for your good words and your question. Well, these are not the easy one, of course, but let's try to see how we cope with them. So first of all, I would say that, namely, when we talk about accountability for war crimes and crimes against humanity committed now in Ukraine, we talk mostly about Ukraine's national jurisdiction, so Ukraine's courts, national courts of our international partners, in particular, well, you know, in Finland, they just had a quite resultive case, was a good result in relation to bringing Russia's national to accountability, and the ICC, the International Criminal Court. Now, as we know that the International Criminal Court works on the basis of principle of complementarity, which means that the biggest responsibility for adjudicating war crimes and crimes against humanity committed on Ukraine's soil is with Ukraine's courts. So only when Ukraine's courts are either unwilling or unable to adjudicate such cases, the ICC shall take them. So that's why, in particular, now we have 6 arrest warrants issued by the ICC in relation to the situation in Ukraine, and they are all against Russian nationals, because Russian nationals we have facts about their crimes, but they cannot be taken by Ukraine's justice. They are outside our sphere of competence now, let's say. They are in Russia. So that's why ICC gave them international orders of arrest. And in such a situation, when we might feel that somebody from Ukraine's side committed something bad, it is for Ukraine's courts to look at these cases and to adjudicate these cases. And we know that since 2014, since the very start of the Russian aggression, we had such cases, and we have them now. So the ICC will not interfere into this if Ukraine's courts do its job. So I think that in such a case, we may be, frankly speaking, secured from some actions in The Hague if Ukraine's courts and prosecution do their job. And in relation to the special tribunal, I'm here more confident that everything should be fine, because the special tribunal has a ratione materia, subject matter jurisdiction over only one crime of aggression. And it is quite obvious for us, all of us here on this call, that crime of aggression is not committed by Ukraine's nationals. Crime of aggression against Ukraine is committed by Russia's leadership, maybe by Belarus leadership, maybe by North Korea leadership, but not by Ukraine's soldiers. So that is why for the special tribunal, I hope and I'm pretty sure that this issue does not exist.
Mhm. Just a historic
Thank
note.
you so much, Ambassador. It totally answers my question.
Okay, I hope so. Just as a historic note, this is not an argument that I agree with, but when George Bush Jr. unsigned the Treaty of Rome, the rationale was that the United States had the full ability to prosecute its own criminals and did not trust the international community, which could have included Muammar Gaddafi and other crazy heads of state. And so the administration of George Bush decided it would not sign the Treaty of Rome. I don't agree with that argument, but it's worthwhile to understand why the United States did that in 2001. This is amazingly complex, Ambassador. You've convinced me, and I think others, that while this is a very complicated series of, you're talking about special tribunals and law of the sea and compensation, and there's so many aspects to this. But you speak of this with a certain optimism, I think. I believe that you, in your extensive work with this, I sense that your own feeling is that much of this can, in fact, be administered. Am I correct in thinking that?
Thank you, Professor. I believe that this is one of the key questions, actually. And I would say that it's quite hard to work in Ukraine's government on these accountability efforts now during the full-scale invasion, if you don't believe in that. So I'm sure that now this is a moment to bring Russia to accountability. Russia never in history faced justice. Never, ever. So I believe that this is a moment when we, together with our international partners, with international community, we can do this. Whether all our accountability efforts succeed, we may not know now. But I'm sure that our task and our mission is to do whatever we can to bring Russia to accountability. And I'm sure that actually, as you mentioned, Professor, that this can be done.
Mm-hmm. I guess we're nearing the end of our hour. I still would ask the 100,000 individual cases. Is that a separate issue, Ambassador? Is that something you are dealing with? I know that Georgetown University has an official arrangement with the Ukrainian Ministry of Justice. Caseload management is a major problem. I don't, there of the 100,000, I think there have been 2 or 3 that have been adjudicated. Is this something that you deal with at all?
Professor, so we have now more than 170,000 of registered cases of war crimes and war-related crimes. And since this is about ensuring individual criminal accountability for these crimes, so Prosecutor General's office and regional prosecutors' offices throughout Ukraine deals with this issue. So as I understand, they are the partners of, in particular, Georgetown University in this work. So we do not work on this as we are the Ministry of Foreign Affairs. We work namely and mainly with the accountability of the Russian Federation as a state under international law. But we also work with only one project or mission on individual criminal accountability. This is a special tribunal for the crime of aggression. All the other individual criminal accountability work is done by the Prosecutor General's Office of Ukraine and regional prosecutors' offices.
That's, I think, an unenviable task because 170,000, oh my gosh, many of them are either no longer in Ukraine or they're dead, correct? So prosecuting them will be an enormously difficult process. We just hope for success both on the micro and the macro level, which you have described. This is an amazing explanation. I've been taking notes here, Strasbourg and Special Tribunal and UNCLOS. I didn't realize that UNCLOS was actually, of course, the Black Sea. That's the sea. If other participants today have comments or questions, I encourage those. My final question to you, Ambassador, would be, I would say at least half of the Ukrainian participants in this course are either law students or they are practicing lawyers. What advice would you give to them in the development of their own individual careers?
Thank you, Professor, for this final question. Well, I think the main thing is to understand what you want to do. So if you want to become a judge like Ms. Fonova, or if you want to become a prosecutor, or if you want to become an attorney, or if you want to become a human rights defender, NGO expert, activist, or if you want to become an academic, or if you want to become Ukraine's government official in the field of international law. So I think this choice mainly, and this your willing, namely, then paves the way to your personal career in each of these perspectives. And it differs a lot. So to become a judge, you need to have separate qualifications. To become prosecutor, some other separate qualifications. To become a specialist in international law, you need to have separate qualifications, namely in the field of international law. So I would say just it's important to be yourself, to listen to your inner voices, what you want to do in life, what you want to do in professional life, how you want to build your professional career. And in the very end, if you want to work with international law in Ukraine's government, there are a lot of opportunities. We search for young lawyers who want to serve Ukraine with international legal mindset. We're always open. But for those of you who want to work with international law, you also must understand that international law is a separate thing. You need to understand it. You need to work with it. You need to live with it. You need to have an international law headlong or mindset in order to get the job done. But now in Ukraine, you have plenty of opportunities to realize yourself in any kind of legal profession.
I haven't heard that in a long time. In the United States, students are frankly demoralized at the professional opportunities with the Agency for International Development being removed and the government in a shutdown. It sounds as if Ukraine, in this particular aspect, is a much more hopeful thing. On a very concrete level, Ambassador, how in the world have you managed to develop the memory that you have for facts and dates and figures? How would a law student is there a methodology for remembering all of this?
Professor, I don't think so. It just you need to live with it.
Yeah.
I live with a special tribunal for almost 4 years.
Okay.
Actually, this is my child, if I may say so. So
Okay.
this is more than a job.
Well, this is absolutely wonderful. I've learned tremendously, and I'm guessing that our Ukrainian participants have learned more than I have because they're more aware of the atmosphere of what's going on outside of the parameters of this discussion. So we're extremely grateful to you. I see emojis. I don't know if you see them. They're flooding. This is, and we wish to meet you. Oh boy, here comes, wow, here they come. Everybody, thank you, Elena Fonova. Thank you, Ambassador. This has been really amazing. Just to repeat, on Thursday, we go to an entirely different subject, which is the communities in stress. Vicki Taylor works for the Prince George's County, which is a northern county in Virginia, not too far from Washington, D.C. And she's developed the ability to deal with traumatized communities. So this would be crisis of a very different sort. It all fits. What we all want is for humans to suffer less. And Ambassador, we thank you for spending your efforts in doing that and for spending this hour with us today. Thank you, everybody. Thanks.
Thank you, Professor. Thank you, Elena. Thank you to everybody, and have a wonderful continuation of this great course.
Thank you so much. Thank you. Bye-bye. Bye-bye.
Bye.